Welcome back to the RGE Limited boardroom. If you thought our mergers were intense, wait until you hear about what happens when the biggest names in Tanzania, specifically the Said Salim Bakhresa empire, take their grievances to the High Court. Grab a glass of whatever is expensive because we are diving into a half-billion-shilling disaster that started with a spark and ended in a very cold boardroom reality check. Here is your high society briefing on the Rusumo fireball served with the signature of Oksana's touch. The scene, a 500 million shilling inferno. On a Tuesday in August 2018, near the Rwanda border at Rusumo, things went from professional to catastrophic. A fuel tanker belonging to Lake Trans Limited, loaded to the brim with petrol, lost control due to brake defects and slammed into 4 Bahresa trucks and 5 trailers that were just sitting there, minding their own business while waiting for permits. The resulting fire did not just damage the fleet, it gutted it to ashes. We are talking about a claim for 501,609,521 shillings and 55 cents. For most, that's a fortune. For Bahresa, it's a matter of principle. The boardroom battle, Bahresa versus Britam. Bahresa's team marched into court demanding the full value of those vehicles from Britam Insurance, who held the third-party policy for the fuel truck. But here is where it gets delicious for us corporate types. Britam didn't just roll over. They looked at the fine print of their contract with Lake Trans and offered a measly 7,498,268 shillings and 69 cents. They basically told the billionaire in shillings, sorry about your fleet, but our policy has limits and your proof is lacking. I'm citing from the judgment here. The scandal, the old receipt mistake. In the RGE Limited boardroom, we know that if you want a check for 500 million, you need 500 million shillings worth of proof. Bahresa's finance manager, acting as the star witness, PW1, brought in original purchase invoices from 2012 and 2017 to prove the value of the trailers. The judge, however, wasn't impressed. Why? Depreciation. You cannot expect a court to award you the new price for trailers that have been hauling cargo across East Africa for years. The court noted that Bahresa failed to provide a contemporary assessment of the trailer's actual value at the time of the accident. In the world of high-stakes litigation, close enough is not strictly proved. I'm citing here. The ruling, a masterclass in pleadings. Bahresa walked away with the 7.4 million Tanzania shillings Britam had already offered, and not a single cent of interest. Why? Because their lawyers put the interest request in the prayer section, but forgot to explain why they deserved it in the body of the suit. My final take. This isn't a story about a loss. It's a lesson in specific damages. If you're going to claim 500 million shillings in the RGE Limited boardroom or the High Court, you'd better have an assessor who knows the difference between a 2012 trailer and a 2018 wreck. Always remember, darlings, The court doesn't award you what you paid, it awards you what you can prove. Now, if you'll excuse me, I have to go to check the depreciation schedules on my own fleet.